Bismillahirrahmanirrahim. Today we will discuss the criminal cases pre-trial stages as governed by Cr.P.C and supported by relevant case law and relevant sections. Each stage has legal implications and the court has to interpret these stages through various judgments. Below is a comprehensive explanation of the pre-trial stages with the reference to the section of Cr.P.C and relevant cases law. Registration of FIR. The FIR under section 154 is registered and it marks the initiation of criminal proceedings. It is filed under section 154 of the Cr.P.C by person who has knowledge of cognizable offence. In Lal Khan versus State versus SHO Police Station, P.B. 2014 SCMR 1511, the Supreme Court of Pakistan held that an FIR must be registered promptly to ensure the integrity of the investigation. Delay in lodging the FIR could create doubts about authenticity of the cases. Second stage is investigation by police under section 156 to 168 Cr.P.C. After the FIR is registered, police have the authority to investigate under section 156, which includes collecting evidence, questioning witnesses and arresting the suspect, and also recording the statement of all the persons who are acquainted with the facts, including witnesses under section 161 and defense witnesses. In Muhammad Ali versus State PLD 1996 Supreme Court 274, the Supreme Court emphasized that thorough and impartial investigation is vital for ensuring justice. The investigation officer must be objective and avoid bias or favoritism. That should be impartial, fair, and every evidence, both sides should be collected during the investigation. Section 157, if the police officer decides not to investigate, he must inform the complainant and a magistrate can order an investigation if necessary. Third stage start arrest and remand under section 46 and 167 of Cr.P.C. After arresting the accused, police must produce them before a magistrate within 24 hours under section 61 of the Cr.P.C. If further investigation is required, police may request remand. Under section 167, a magistrate can grant either police remand custody of the accused to the police for up to 14 days, but from the shortest remand it should be granted and there should be a reason, or judicial remand custody of accused in jail. In Kashif Ali versus Judge Anti-Terrorism Court, PLE 2016 SC 951, Supreme Court laid down the guidelines for granting remand, emphasizing that police remand should only be granted in exceptional cases and when further investigation is necessary. It should not be merely given for any discovery. Third stage start after arrest, bail proceeding. After arrest, the accused may apply for bail. Section 496 provides for bail and bailable offences, while section 497 covers non-bailable offences, where bail is granted only in exceptional cases. PLD 2005 Supreme Court 530 and 95, and the various case law that the court held that bail should not be withheld as a punishment. It also ruled out that the non-bailable offences, bail should be granted if there is no reasonable ground to believe that the accused committed the offence, or if case fall in the ambit of further inquiry, or if case does not fall in the prohibitory clause, and there are not exceptional circumstances for the refusal of the bail. 5-stage filing of a Chalan under section 173. After completing the investigation, the police file a Chalan charge sheet under section 173, summarizing the evidence and listing the charge against the accused. This is final report. If insufficient evidence is found, police may file a final report recommending that the case be closed or be cancelled. Case law, the State versus Khalid Ahmed, PLD 1994, Supreme Court 828. The court held the submission of the Chalan is necessary for the commencement of trial. The Supreme Court further clarified that the accused had the right to access all documents and evidence submitted with the Chalan. Cognizance by the court. 190 to 204 Cr.P.C. After receiving the Chalan, magistrate decide whether to take cognizance of the offence under section 190. If sufficient ground exists, the magistrate can issue summon or warrant under section 204, both in complaint case and in FIR case. Zaur Ahmed versus State 2017, Supreme Court 1662. The court emphasizes that a magistrate must examine whether the material before them justifies taking cognizance and proceeding with the case or not. 7 stages of framing of a charge sheet. Section 265D. Once the court takes cognizance of the offence, the next step is framing of a charge under Section 265D. Charges are read over to an accused, and if accused pleads not guilty, the case proceeds to trial. In Muhammad Asghar versus State PLD 2008, Supreme Court 513, the court ruled that charges should be framed clearly and accused must understand the nature of the charges before entering a plea. Plea Section 265E. In certain cases, pre-bargaining is allowed under Section 265E. Accused can plead guilty in exchange for a lesser sentence or reduced charges. In case State versus Abdul Aziz Khan, PLD 2007, Supreme Court 247, court clarified the process of plea bargaining and emphasized that the accused must fully understand the consequences of the plead guilty. The pre-trial strategy in Pakistan criminal justice system as governed by the Cr.P.C. ensure that the legal rights of both the accused and the complainant are protected through FIR registration, investigation, arrest, remand, bail, filing of Chalan, and framing of charges. The court assesses the merit of the case before it goes to trial. Case law has further clarified these stages, ensuring due process is followed in line with the constitutional protections. 8. Supply of copies and engagement of a counsel are important procedural steps in criminal cases, but they are not directly categorized as pre-trial stages. However, they are crucial administrative steps that occur after the pre-trial stages, after charges are framed, and before actual proceedings begin. Supply of copies, Section 265C. Once the charge sheet is submitted and accused is formally charged, Section 265C of the Cr.P.C. mandates that the accused be provided with copies of all relevant documents. This includes the FIR, statement of witnesses, recorded under Section 161, and any other relevant document or evidence that the prosecution intends to rely upon. Purpose of supplying these copies is to ensure fair trial rights as enshrined under Constitution of Pakistan, Article Section 10A. The due process of law. The accused must be fully aware of the charges and the evidence against them to prepare a defense. Muhammad Nawaz versus State 2010, YLR 2323, the court ruled that failure to provide copies to accused is violation of fair trial principles and it could lead to delay or nullification of a proceeding. Second, is also part of this stage that the engagement of a counsel under Article 10 of the Constitution of Pakistan. The right to be represented by lawyer counsel is a fundamental right under Section 10 of the Constitution of Pakistan, which ensures that an accused person has the right to a fair trial and the right to engage legal counsel. Legal aid. If accused cannot afford to hire a lawyer, the court may provide legal aid or appoint a public defender to ensure that the accused has legal representation. This step is crucial for ensuring that the accused receive a proper defense. And further, District Legal Empowerment Committee has also been under the Constitution made to provide the lawyer to such a person who are deserted and who cannot afford. The engagement of counsel typically happens before the trial starts, during the pre-trial stages, or immediately after the accused is charged, so that the counsel can prepare for the case. However, the formal trial preparation begins after the engagement of the counsel. Shahbaz Khan versus State PLD 1998 Supreme Court 276, the court held that denying an accused the right to be represented by a lawyer amounts to a miscarriage of justice. Supply of copies is typically considered a pre-trial requirement but happens after the framing of charge and before the trial proceeds. It ensures that accused is adequately informed and prepared for trial. Engagement of counsel is a right that accused exercises at various stages of his case. It is critical for ensuring a fair trial, but it is not categorized as a formal pre-trial stage. However, it is necessary to have counsel engage before trial officially begins. In summary, supply of copies and engagement of a counsel are essential procedural rights and administrative steps that occur after the formal pre-trial stages: registration of FIR, investigation, framing of charges, but before the trial formally begins. They are governed by the Section 265C of the Cr.P.C. and Section 10A of the Constitution of the Pakistan. Thank you.